Hello and welcome to part 3 of our series looking at proactive management of commercial leases. My name's Claire-Elaine and I'm a partner at Gunnar Cook specialising in property dispute resolution and risk management. So just to recap what we've covered in part 1 and part 2 so far of this series. In part 1, we were looking at the beginning of the lease and things that you would like to consider when you're drafting your heads of terms and when you're putting your leasehold document in place. It will become apparent during the course of today's webinar why some of the things that we raised in part 1 become particularly pertinent when you're dealing with issues such as variations later in the lease. In part 2, we looked at some other common issues arising during the lease, and we're carrying on with that theme. So today we're talking about variations to the lease. Now, this is not just variations, for example, where you're changing the wording of the lease by way of deed of variation. What I'm talking about today are those things that come up in the course of the lease that will change those original heads of terms that you had in mind. So, for example, it may alter the rent, it may alter the term, it may alter the property itself, in that way varying the lease. So why does this matter? Well, you can be reactive and you can just wait to see what happens and to see who picks up what under the terms of the lease. The problem with that is that you're always on the back foot. So what we're trying to encourage here is thinking about these issues in advance. So what I would like you to be able to do is to anticipate workflow, to know when these things are coming up, to know what to expect and to be ready for them. To be able to deal with them in a way which is going to minimise any issues and hopefully avoid any disputes. We want to be thinking about how do we keep control of these situations, and in doing so, how do we save cost and at the end of the day, maximise the profit and maintain the portfolio properties. So what we'll be covering today is we'll be spending the majority of the time looking at rent reviews and break options. These are both quite complex areas, so I'm only going to be able to touch on some key points in respect of each of them today. But if you need any more detail, you can always get in contact with me. And then we'll finish off by looking at some key points with regards to assignments, alterations, and subletting. Some of these points are quite repetitive, so you'll find that we probably skip through those a little bit quicker. So let's start off then with rent review. Well, when you're considering what type of rent review you are going to have, there are essentially two different types that you have to choose from. The first is escalation and the second is revaluation. Now, escalation essentially means that your rent is going to be reviewed by reference to some form of fixed index. So that can be an index internal to the lease, as in a list of uplifts that have already been pre-agreed, or it can be an external index, and we'll come on to the slightly different types in a moment. Revaluation is what some people might refer to as a proper rent review, and that's where the amount payable is reassessed at fixed points during the term of the lease. Now, it's important that you have within your toolkit an understanding of all the different types of rent review that might be open to you, because some are better in different circumstances. The thing that you don't want to have is a rent review that just happens to be that way because that was what was in the precedent that your solicitor happened to be using at the time. A bit more thought here can save you an awful lot of hassle down the line, and it can also see better returns for your property. So let's have a think then about the different types of options that you can have. So the first one to think about is stepped increases. This is the most simple. This is where you say in the lease, the starting rent will be this amount, and then on this date it will rise to X amount, and then on this date it will rise to Y amount. So at the beginning of the lease, everybody knows exactly where they stand, and there is no dispute about how much the rent is going to go up by or when it's going to increase. This avoids disputes, but obviously it doesn't take into account market forces, so it may end up being more or less unfair to one or other of the parties. does work well though for shorter leases, and with the trend in commercial property leases being that they are shorter these days, it can work particularly well. The second way that is very popular at present is indexation. And this is where the rent review is linked to an external index, quite often the retail price index. But the problem with the RPI is obviously that is linked to changes in the retail market, which doesn't necessarily reflect changes in the property market. So while it does give some idea of market forces, it's not necessarily an accurate reflection of the rental value of the property. The other thing to bear in mind with RPI, which has caught quite a few people out recently, is that within the first 5 years of the lease, if there is a rent review, and in particular in the first 5 years, you have an issue with stamp duty, land tax, or land transaction tax. If you have an index-related RPI rent review within your lease, then it is exempt from those tax increases, but only if the increase is linked directly to the RPI. If you've got an RPI plus 1% or plus 2%, anything that alters the bare RPI figure is going to cause you an issue and potentially mean that you've got tax liabilities there. So just be careful of that. The other thing to bear in mind with indexation as well that you can do is you might want to link it to that external index, but you might want to cap it. And there is something called capped and collared review. And what that means is there is a minimum amount by which the rent will increase and a maximum amount by which the rent will increase. So it gives some flexibility for the market to have an impact on the rent review, but it caps it so the parties have got some more certainty there. Again, indexation is quite easy to do. And therefore it's quite popular with the shorter commercial leases that are coming in at the moment. Turnover rent is a way of doing rent review, particularly popular with retail shops. What this does is it looks at the basic rent, and then there is usually an additional percentage rent payable based upon the turnover of the individual business. It's very helpful if you've got a new venture starting out who's not sure if they're going to be successful or not, or if you're putting in place a new use for that property. So, for example, if there wasn't a shop there before, or if it's a different type of shop that's going into that particular property. So this is again becoming popular. Most landlords will expect there to be a base rent there and a percentage then linked to the turnover rather than the full sum linked to the turnover. And again, that's quite easy to do on an annual basis. You then come on to the rent reviews, which are the revaluation ones, which is market rent. Now, market rent would seem to be the fairest way of reassessing the rent when it comes to leases, because what you're doing is you're looking at a fixed point in time and assessing what the market rent would be at various points during the term of the lease. The funny thing is, though, that the fairer that you try to be in respect of rent reviews, the more likely you are to have a dispute. Because as soon as you start talking about market rent, you need to then nail down exactly what you mean by market rent at that point in time. And you need to decide which factors you are and are not going to take into account. So while it is giving a fairer snapshot in time of what the rent should be at that point in the term of the lease, it does mean that there is a lot of room for variation and a lot of room for argument. So the way that these rent reviews are usually structured allows the party to negotiate what they think the market rent should be, and if they're unable to agree that, they have the option to refer it out to a third party for determination. You can have market rent where there is a minimum upward review, and you can also have upward only rent reviews. These are still fairly common. Obviously, with the uncertainty of Brexit coming, and it being unclear what that's going to do to the market, a lot of tenants, though, are starting to push back now and suggest that a market rent review should be just that. So thinking then under leases, if you're in a chain of leases, so say, for example, that you are the head lease, so you've got a freeholder sat above you, you have a head lease, and you're dealing with rent reviews in an under lease that you're granting, what you need to think about is the rent reviews that are in your current lease, because you do not want to be in a position where the head lease rent goes up and there's nothing that you can do with regards to the under lease. So usually there will be a mechanism for linking them. It's worth bearing in mind that the rent review is not a formal variation of the lease if it's done with regards to the terms of the rent review clause. So as long as you keep within the scope of that rent review clause, it's not a formal variation. And that becomes key, particularly where you have a guarantor, because it means that you can uplift the rent with the guarantee remaining in place. The thing to bear in mind, though, where a lot of people fall down, is that if you decide to change the scope, so for example, say you had an indexed rent review clause and you decided that you were going to agree between the parties, then actually no, you're going to do a market review. Well, the problem with that is you're actually varying the terms of the lease. So at that point, you need a deed of variation and you need to have the permission and inclusion of the guarantor in order to keep that guarantee on the rent going forwards. It's worth having a think about frequency of reviews. As I said before, a lot of commercial tenancies are becoming shorter and shorter these days. So you need to have a think about the nature of the review and the expense of the chosen mechanism, and also practical issues with regards to dates. It's very straightforward to do a stepped review where it just comes into force, or even an indexed or turnover review annually. But a market review is quite an undertaking, so generally they're only used in much longer leases, and you wouldn't be wanting to do one of those every year. You'd be looking at every few years at least. In terms of dates, it's important to try to put in place a specific date for rent review. Quite often you will come across tenancies where they try to pin the rent review on an anniversary, and that is far from ideal. And I'll explain when we come on to break notices what the issue is with trying to work out anniversaries when it comes to tenancies, because they can be particularly difficult. In terms of time as well, is time of the essence? Well, generally it's not when it comes to rent reviews, and what that means is the rent review can come and go without anybody doing anything about it. And it can sit there in the background, sometimes for years, and then suddenly the landlord realises they should have exercised it. We go through the rent review process, and that means that the tenant has got significant balancing repayments and interest on all the balance of the uplift that hasn't been paid. And that's the point at which it's ripe for disputes. So it's often helpful to keep an eye on your rent reviews, because while you may think, well, it's fine, we're covered because we are going to get the balancing payment and interest on it eventually, actually what you're doing is you're stocking up an issue, both for yourself and for the tenant, and potentially also the guarantor, which may be very costly and difficult to resolve. And even though you will often recover the majority of your costs for having to deal with that kind of dispute, it's certainly unlikely that you're going to recover all of them. So it's worth keeping them it's worth keeping an eye on when those dates are and trying to do your rent reviews in a fairly timely fashion. In terms of tenants, commercial tenants, the last thing that you really want to have is an open rent review hanging over your head if you're not certain as to how much the uplift is likely to be. So if that happens, ideally you want to be looking for an option in your rent review that means that you can serve notice to make time of the essence and essentially force the landlord to start the process, because otherwise you could be operating in a situation where you're not entirely sure what you need to be setting aside against a potential uplift in rent for a significant period of time. So as I said, late rent reviews, you need to bear in mind that there will be a balancing payment and there will be interest on the sum. So what are the top tips for dealing with rent reviews? Well, the first one is be practical. Don't just go with the precedent. Think about what are you actually going to have to do in order to put this rent review in place. When is it coming up? It's no good having a rent review that's going to come up right in the middle of the summer holidays or at Christmas time when you're going to find that parties aren't available for discussions and so on. So have a think about when it's going to fit into your workflow. When's the ideal time? People tend to go for anniversaries, but there is no rule stating that that needs to be the case. So make it convenient to you. Try to keep drafting clear as possible. Remember that the more complicated you make it, the more likely you're going to have a dispute. This is particularly the case when it comes to market rents. So you may think that you're being helpful, making the matter more and more complicated with lots of specifications, but actually just be aware if there's any ambiguity or particular complexity there, there's a potential there for a dispute. And you're setting those clauses as well. You need to make sure you're being realistic. We often see people thinking that they're helpful, particularly again with market rent, where they put in place suggestions that the property would be used for X or such and such would be the case. Whereas in reality, the property would never get planning permission for that type of use, or the other points that they've specified may not be realistic. If that's the case, it then becomes increasingly difficult for a valuer to find comparables. And again, what you are then opening yourself up to is a hypothetical situation which could be argued through the court in a significant and costly dispute. You need to allow in your plans for rent reviews consideration for alterations. If there's alterations to the property, that might alter how much the rent for it will be. You also need to give some consideration to outstanding rent reviews. The good news is you don't need to be serving notice as soon as a rent review becomes due on guarantors. It's only once it's been determined that you need to serve your notice under Section 17 of the Landlord and Tenant Covenants Act 1995. But you do need to bear in mind that if you've left it for a considerable period of time, it may come out of the blue to the guarantor who's not realised that this has been accruing, and that might make your recovery more difficult, as I said before. And as I said previously, you also need to have a think about making sure that there is a possibility of making time of the essence. Now, your rent reviews are often linked to your break options. So if we move on to having a look at break options now. Break options. So the code for leasing business premises in England and Wales is a guidance code. It's not binding, but it does give a suggestion of best practice. And what that recommends is that the only requirements that a tenant should have to comply with in order to exercise a break option are that the rent is up to date, that they give up occupation, and that they leave behind no continuing subleases. The code suggests that disputes about states of the premises, so repair or what's been left behind, should be settled later. So what they're looking at there is repair and vacant occupation should be left for later. So let's have a look at why some of these issues with break options might be a problem. So bearing in mind that code, they've tried to simplify it as much as possible, and you'll see why that has been the case as we move on through this. So first off, let's have a think about who can exercise a break option. Now, a break option might be just a general break that the tenant and any successors in title, or the landlord and any successors in title, can exercise at any point during the term of the lease. Alternatively, they can be made personal. So it might be that you want to negotiate a personal break with the tenant who sets out with the lease initially, but that you don't want there to be a break if it's assigned subsequently to another party. You can have two types of breaks. They can be rolling or fixed. So your fixed break date is a specified date during the term of the lease, and a rolling break date is usually specified as being after a specific date. So much of the term will run, and then at any point after that date, the tenant can serve or the landlord can serve notice. Now, when you are setting out your dates for the fixed break date or for the rolling date to start, you need to have a think about how you specify that. Again, ideally, you want that to state a date, not an anniversary. And I'll give you an idea as to why trying to go off an anniversary can cause significant problems. Now, inevitably, when you're dealing with break dates, it's often the case that parties leave things until the 11th hour and serve things at the last moment. So say we had a lease that was starting today, and say there was a break option on the 10th anniversary, just for ease of numbers. If that lease said that the term ran from the 5th of November 2018, then legally the lease term would exclude that day. So the 10th anniversary is going to be on the 5th of November 2028. So as long as you serve by that date, you're fine. But if the term is specified as beginning on, so on as opposed to from, the 5th of November 2018, then legally the term includes that day. So that means that your 10th anniversary is actually on the 4th of November 2028. So if you come along and start trying to serve your notice then on the 5th of November, you're going to have a problem. And there are variations of the wording in between as well, which give even more confusion. So rather than leaving it open to debate and argument, the best thing to do is to put a fixed date in there. And that's the same for your rent reviews as well. And they can be completed at the point at which the lease is completed. In terms of the conditions, now conditions should be realistic. They need to think about paying all the rent, but you need to know what's reserved as rent. You might want them to perform all covenants, or to perform all the repairing covenants. And this comes back to the point the code was making. It's actually very, very difficult, if not impossible, for a tenant to ensure that to be the case. Because it's much more easy for a landlord to say, I'm not happy that you've complied with the repairing covenants because I don't like the colour of the paint and I haven't given approval to my satisfaction for the repairs that have been done, and frustrate the break option. So that's why the code suggests that that's not a good way of proceeding with break options, because it's just healthy there for a dispute. The other thing is vacant possession. You want the property to be handed back, obviously, but vacant possession requires that there should be nothing in the premises that would hinder the landlord taking up normal occupation. Now, it has been found on case law that vacant occupation has not been given even where tenants have left rubbish in the premises waiting to be collected. It doesn't take much for vacant occupation not to have been given, and again, this makes it very easy to frustrate break by a tenant, which is why it's suggested by the code that's not included. In terms of landlords' breaks, it's worth remembering that the most common one for landlords is a requirement that they must intend to redevelop the premises. If you are dealing with a lease which is within the 1954 Act, you need to make sure that that requirement reflects Section 31F of the Landlord and Tenant Act 1954. If it doesn't, you're going to have problems again with that condition lining up with the 1954 Act requirements in order for the break option to be exercised. So you need to be realistic about your conditions. You might think it's being clever to try and make them so difficult that nobody can comply with them, but actually, again, it's just going to be ripe for an expensive dispute. If you don't want to give a break, don't give one. If you do want to give a break, then make sure that it's easy to actually exercise it and clear for all the parties. In terms of notice provisions, you need to make sure that these are particularly clear. Where you've got joint tenants or joint landlords, you need to make sure that you've served on behalf of all of them and make sure you've served on all of them. service requirements are going to be strictly construed, and there's a famous case called Manai Investments and Eagle Star Life Assurance from 1997, where Lord Hoffman said if a clause has to be on blue paper, it's no good serving it on pink. The courts will view your provisions of your break options as a commercially negotiated agreement, so they're very reluctant to interfere with them, and they will strictly construe them. The only thing that they will do is if there is perhaps a minor defect in the wording, but it's clear what the notice was intended to do, they may allow that notice to be valid in those cases. In terms of methods of service of the notice, that's even more strictly construed. And there was a case I was involved with back in 2009 in the Court of Appeal, which was called Orchard Development Holdings and Reuters. And in that case, the tenant, Reuters, had the option of serving notice. They could have served it by recorded delivery, by hand, or by fax, but they could only serve it by fax if the fax was acknowledged by the landlord. So, as with many tenants, they left it to the last minute. They were too late to post their notice. They sent someone to post it by hand, but they stuck it through the door of a property a couple of roads over. And so that wasn't validly served. And so they had to rely on the fax. Now, Orchard Developments were alive to the fact that a break date was coming up, and they knew how it could be served. And they also knew that if it came in by fax, they needed to decide whether they wanted to acknowledge it or not. So because they were forewarned, what they did is they told their staff that if a fax came in, it needed to go straight to the directors and nobody was to acknowledge it. So even though the fax said, please acknowledge safe receipt, it was passed up to the directors, who immediately called us and said, do we have to acknowledge this? We confirmed they didn't. So we went to the High Court, and Reuters argued that they'd sent the fax. Orchard said, yes, we got it, but we decided not to acknowledge it because we've got no obligation to do that, and the High Court agreed with them. It then went up to the Court of Appeal because Reuters said, but hang on. Orchard confirmed that they received the fax in their statements of case for their claim in the High Court. So therefore they acknowledged it as part of their statements of case. The Court of Appeal dismissed that and restated again that they will strictly construe exactly how notice needs to be given. So again, notice needs to be given. Your provisions should be as clear as possible, and please make sure that you're aware of how and when notice needs to be given. Whether you're a tenant or a landlord, as a tenant, you need to do it in good time because it's going to take time to actually draft your notices and to get them served properly. And as a landlord, you need to be aware of what might be coming in and when it might be coming in so that you don't miss something. You also need to be aware of not waiving your rights, particularly as a landlord. If you're disputing a tenant's right to break, then you shouldn't do anything that might waive your rights or waive a condition, such as accepting keys or taking security measures at the premises. If you absolutely need to go in and secure the premises to protect your asset, then you need to make sure that there is formal notification that the action you are taking is without prejudice to your position. Otherwise, you could find that you've accidentally waived the conditions of the break. Make sure that you've planned things in advance, particularly where there are onerous conditions, and also make sure that that line of communication is going to be open, particularly between the landlord and tenant in the run-up to any dates where you've got a break option coming, so that there's some indication of what the parties are intending to do. Thinking about a couple of other things that come up, breaks in the middle of rental periods. This was clarified, thankfully, in 2015 by the Marks and Spencers and BNP Paribas case. Now, be careful if you're looking this up, because what happened is the court changed its mind a few times as it went up. So it started off in the High Court, it went to the Court of Appeal, and then it went to the House of Lords. So it's the House of Lords decision that you need to make sure you're looking at if you come across any blogs and so on. And the final resting place was that if rent is payable in advance, then the tenant is not entitled to any refund. So if the break date is the day after a quarter rent payment, that means the tenant has to pay the full quarter and they will not be entitled to any refund. So that's worth bearing in mind. You need to remember as well, subtenants, if the break is operated, then the subtenants under lease will also come to an end. If you want to keep the subtenant in place, then you need to be looking at surrendering the head lease as opposed to operating the break option. You also need to be aware, though, as well, when it comes to subtenants with the break option, if the subtenants have got protection under security of tenure under the Landlord and Tenant Act 1954, because the break option will automatically end their contractual lease, but the statutory lease will continue by virtue of that act, so you would still need to serve a Section 25 notice on them. Final point on break notices then is, why would you get somebody else to serve them? Even if you've made your break option very, very simple, why get somebody else to serve it? Well, the bottom line here is insurance. Break options can be very expensive if they go wrong. They're quite technical. It's quite a technical area of law to get right. Even with ones that you think are particularly simple, it's quite easy to get it wrong. If you're serving the notice yourself, you've got no comeback if you get it wrong. If you're an agent and you're serving notices, you need to make sure that you're covered by insurance because the consequences can often be quite costly. If you get a legal professional to serve your notices for you, then not only do you get the benefit of it being more likely that they're going to be technically correct, but you also get the benefit of their indemnity insurance, which means if anything does go wrong, essentially your attempt to exercise the break is underwritten. So it's worth just bearing that in mind going forward with break options. Okay, let's move on then quickly. As I said, the last three we're going to skip through a little bit faster. Assignment then. You need to have a restriction. If you don't put restrictions in a commercial lease, then the tenant is free to do what they want to do. You need to bear in mind that if a tenant does assign a lease without the proper consent to do so, it's not going to invalidate the assignment, but it is going to mean that you might have a claim against them for breach of the lease. What you need to be careful of, though, is that you don't start accepting rent from a new tenant or start treating them as a new tenant, because that might suggest there's a waiver of the requirement for consent. So this is where those checks on rent, making sure you know who the rent is coming in from, making sure that you keep a relatively a constant eye on the property. I'm not suggesting you should be down there every week or month, but every few months, if you pop by and somebody else seems to be in there, that should be raising some alarm bells with you. If you've got an absolute prohibition on any kind of assignment, so you may not assign under any circumstances under this lease, then you're going to need to issue a deed of variation in order to allow an assignment. If you've got assignment by consent, you need to bear in mind the requirements of the Landlord and Tenant Act 1988, which requires you to give consent except where it's not reasonable to do so. Now, a lot of tenants will push to say it's expected that you give consent, but the second part of that is very important. It's not where it's not going to be reasonable to do so. It is reasonable for a landlord to expect to have full information about the tenant. You would expect to be doing the same sorts of checks that you did when you took on the initial tenant. So if that information has not been provided to you by the tenant who wants to assign their interest in the lease, then you need to be asking them to provide it, and it's not unreasonable for you to do that. So don't feel that just because the 1988 Act is there, that there is any pressure on you to accept what would not be considered to be a reasonable tenant. You need to give consent within a reasonable time. Now, again, that depends very much on the provision of the information being prompt. So if a tenant wants to get an assignment moved on quickly, then they need to provide all the information that's going to give the landlord reassurance so that they can respond quickly. You've got to give written notice of the decision. That can be a letter or an email. It doesn't have to be anything more formal than that. And you must pass on notice to anyone else who needs to give consent. So if you're, for example, holding a head lease, then you might need to pass it on to the freeholder. Section 19(1)(a) of the Landlord and Tenant Act was inserted in 1995 by the Landlord and Tenant Covenants Act. And what that's given you the ability to do is to agree circumstances in which the landlord may withhold consent and put conditions subject to which consent may be granted. So that has given you a degree of control again. So that does mean that you are able to say, under certain circumstances, I will not be granting consent to an assignment. And it does mean that you can put conditions in place for that consent to be given. So what kind of conditions would you be looking for? One of the biggest ones that comes up is the authorised guarantee arrangement, which is usually put in place. That's the outgoing tenant guarantees that the incoming assignee is going to comply with all the terms of the lease. In terms of guarantors generally, you need to bear in mind that your initial guarantor for your initial tenant will not be able to guarantee the assignee, because of Section 25 of the Landlord and Tenant Covenants Act 1995 prohibits them from doing that. This is particularly tricky where you've got a group of companies and you've got an intra-group transfer of the lease and the parent company is expected to guarantee both. They can't do that. The only thing that the initial guarantor can do is guarantor the original tenant's compliance with the authorised guarantee agreement. So just bear that in mind when you're dealing with your guarantors. Another condition that's quite usual is you need to require that rent and other sums payable under the lease are up to date. Again, this is another reason if you've got an outstanding rent review and you have to then start negotiating that here, that can frustrate assignments and make life quite difficult, and it gives rise to a number of disputes. Remember, as I said, you can withhold consent where it's reasonable. In terms of the application for consent, the code suggests that the tenant should be giving the landlord all necessary information at the outset. Landlord should request further information. It suggests 5 working days is a reasonable length of time, though individual circumstances will be taken into account. And it's down to the landlord to consider whether any consent from third parties is needed. To give you some help there is a voluntary protocol to deal with this process that was set up by Falcon Chambers, and it sets out the type of information tenants should be providing and the types of things that the landlord should be considering. That's a really good template to be using to make sure that you're in line with the process and what you're doing is reasonable, both as a landlord and as a tenant. In terms of alterations then, you'll find that there's a number of the points repeated here. You've got a restriction is required, again. If not, then they can do what they want. Bear in mind you've got Section 3 of the Landlord and Tenant Act 1927, which does allow tenants to make improvements to the premises, even where they are not allowed to under the terms of the lease. But in order to do that, they must go through the notice procedure. They cannot retrospectively claim under that act. You also need to bear in mind that if there is an absolute prohibition, then you decide to vary the lease in order to allow them to make some alterations. You need to get your guarantor on board, because otherwise Section 18 will kick in and it will mean that your guarantor is lost. And again, you need to have a think about 19.2, this time of the Landlord and Tenant Act 1927, which is very similar. Consent's not to be unreasonably withheld and delayed. Note the term there, unreasonably. Bear in mind that you can impose obligations, so you might want to ask them to use good quality new materials, to have a good and workmanlike manner in the way that they're approaching the works. You could ask that they're done to the reasonable satisfaction of the landlord. You could require them to get planning permission. You could require them as well to reinstate at the end of the term. So have a think about practically what obligations you want to give them. in terms of giving any license for alterations, because obviously you're going to have to manage the works with them, and then you're going to have to deal with the ramifications of those works going forward. At that point, you might also want to consider whether they're going to have any impact or change on the rent review provisions that we discussed earlier. Do bear in mind that where there are statutory obligations for a tenant to do work, that will override any restrictions in the lease. But it is worth having something in your lease that says that if that is the case, they still need to agree with the landlord how they're going to approach doing those works, because then it gives you some modicum of control over what's being done with the property. Again, there's another voluntary protocol that I've given you a link for there, another one by Falcon Chambers, and that again will give you an idea of what you should be considering and what may and may not be considered reasonable. So coming on then to our last topic, subtenants. Restrictions are required again, or else they are allowed to sublet at will. Why does it matter? Well, if you've got subtenants in place, as the landlord, you might come into contact with them in a number of different ways. So if the head lease is surrendered or it's forfeited, you might come into contact with them then. You might find that your subtenant has acquired security of tenure under the 1954 Act, so are applying for a lease renewal. You could also find that if your head lease tenant goes insolvent, that they might find that that lease is disclaimed. So there are a number of different ways that you might find yourself coming into contact with subtenants, not least the fact that they are the people that will then be in occupation and looking after your property. That can cause management issues, and if you get it wrong, it could also make your property value diminish, or it could make it harder to market in future. So you need to bear in mind that if there's an absolute prohibition, you've got that section 18 point again that we made with regards to our alterations. And again, if you've got it with consent, bear in mind that you've got the same requirements as you do with regards to assignment under that 1988 Act. You do want to make sure that you're dictating the content of an underlease. It's no good just putting in a line into your tenancy agreement that says we'll give consent for you to underlet. You really want it to be going along the same lines as the initial lease. This is particularly the case if you are a head leaseholder and you're under the obligations of a lease yourself, because what you don't want is a situation where the subtenant who's in occupation of the property actually has less obligations than you do, or less obligations than your tenant does, because that is going to lead to various issues arising, obviously, in terms of how the property is being looked after and dealt with. You want to make sure, ideally, that it's contracted out of the Landlord and Tenant Act 1954 as well. Otherwise, you may find that you can get rid of your tenant, but you may find that your subtenant that's in there has got security of tenure. You also generally want direct covenants between the landlord and the subtenant, so that the landlord can then enforce those covenants about how the property is being used directly, without having to dogleg it through the tenant themselves. There are some additional issues that come up with subletting part. Sometimes tenants need to do this in order to make rent. They may have some areas that they're not using that they want to sublet just part, or they may have decided they can make more money by separating the property up. Bear in mind, if you've got a head lease, there might be a prohibition to doing this in your lease, so you might not be able to grant permission. You need to have a think about planning restrictions, fire safety issues. Is this going to be covered under the insurance, or is it going to have issues with your insurance policy for the building? And you also need to be aware that it may trigger the need for a new EPC. And obviously, if you need a new EPC and the conditions for the EPCs have changed since your last one, there is a risk there that your EPC grading is going to go down, and you come back to the minimum energy efficiency standards issues that we raised in part 1. So there's a lot more to consider when it's subletting of part. It's not simply a case of the tenant saying, well, I'd just like to let out the ground floor, please. you need to have a think about the wider ramifications and issues that it's going to cause, not only in the immediate future, but also at the end of the lease. So that's been a bit of a whistle-stop tour today to go through those points. Our next part is the final one, part 4. We will be considering ending the lease, and that's on the 4th of December at 12 o'clock. So in that webinar, I'll be looking at the 1954 Act, forfeiture and possession, surrender, dilapidations, and tenant insolvency. I realise I have covered an awful lot in this webinar. There's a lot of points that there just hasn't been time to go into in any significant detail. So if you have got any questions, please do drop me an email or give me a call. As I've reiterated in previous webinars, I don't charge for answering quick questions or inquiries, so don't be afraid to get in contact with me. Thank you very much for joining me today.